My client just quite simply can't work. That's been determined by the administration. She does have PTSD and a nerve impingement in her neck and back, which again goes to her extremities. It's very painful. It's an issue that she's dealt with for some time, and it's an issue that was acknowledged by both parties throughout the pendency of their marriage.
Mr. Zandi, this is, I believe, your client's motion.
It is, Judge. I'm going to be brief, I promise. I think this is a situation in which my client is before the court asking for primarily two forms of relief. Number one, I think, is already resolved itself. That's the temporary use and possession of the family home, which is located at 121 Swiftwater Place in Kelso. We are asking that that just be reduced to the order. It appears that Mr. Myers has already vacated that home. My client continues to reside in it. You see my client's position related to that home that was purchased prior to the marriage from what we believe were separate sources of funds. That home is in my client's name. Mr. Myers was sometime later added to that deed or financing purposes, again, for what we believe, and my client details for you, was added for to obtain a lower rate. So clearly financial purpose and financially driven, which I think the law is pretty clear under the Borgie case that remains separate in character. So we are asking that my client remain in that home. Also asking under that same vein for a prohibition against Mr. Myers from accessing the home. You saw some of the concerns detailed by my client. There are some mental health issues. How those are being addressed currently, we don't have a lot of information on that. I do not want to go into specifics. I trust Your Honor read the details of that, but nonetheless, that continues to be a concern of my client. To the best of our understanding, Mr. Myers has largely taken what he wanted out of the garage or the shop structure at the home. And my client details for you as well that there has been significant amounts of cash that he has kind of buried throughout the home. He's taken that too, to the best of our knowledge. So we're simply asking for the order to reflect that my client resides in the home on a temporary basis, and Mr. Myers is prohibited from accessing that home unless expressly authorized or agreed upon between, I would suggest, me and Mr. Brewer. Offices usually communicate fairly well. I think we could probably accommodate any information or any articles of personal property that need to be exchanged, but to the best of our knowledge, that's already been done. Mortgage on that home is a little over $1,000 per month, $1,021 to be specific. That's the big debt. My client also has some credit cards that she details for you. We are asking for the second form of relief in the motion, some kind of spousal support to get us through this transition time. My client quite literally is in financial straits right now. She needs to be able to pay her bills, buy groceries, buy gas, and the like, the items that are referenced in her financial declaration that she provided for you. And I would say that budget is extremely modest, to the point of her claiming only about $150 for groceries a month, which, given the prices at the local grocery stores, is exceptionally low. Those prices continue to go up, but everything she has done, again, she is living exceptionally frugally, and we would like a little bit of support on a temporary basis to offset some of those costs. This is a 17-year marriage. Parties were married back in 2006. My client, certainly given the length of that marriage and the disparity of incomes, which I'll speak to in a moment, again, believes that the request for some support to give her some much needed financial relief is appropriate. As it pertains to the current incomes, Mr. Myers is a retired electrician. He has access to funds through Social Security, which is $2,135 per month. He also collects on a pension, which again is approximately $1,500 a month, and this Empower IRA. During the course of the marriage, there's some back and forth between the parties as to what was being taken and withdrawn from that. My client states at one time that was upwards of $1,500 to $2,000 per month. They reduced that. Once my client qualified and received her Social Security disability payment, which is $1,425, and Mr. Myers began taking $1,000 per month. He can take more. There's nearly $500,000 in that account. It's north of $400,000. Given his age and given his stage of retirement, he could basically reasonably take anywhere from $1,500 to $2,000 per month. And so again, that's an untapped resource that he's been modestly drawing off of, but that can fluctuate. What we're asking for is some support in the amount of $2,000 per month. Now that would roughly equalize the incomes. After 17 years of marriage, we believe that's reasonable and appropriate. And we're asking you to adopt that form of relief. And my client just quite simply can't work. That's been determined by the administration. Now, she does have PTSD and a nerve impingement in her neck and back, which again goes to her extremities. It's very painful. It's an issue that she's dealt with for some time, and it's an issue that was acknowledged by both parties throughout the pendency of their marriage. There is some red herrings in this case. Mr. Myers states that my client is making money from as a musician, very part-time, as well as some pottery and artwork type of things. We've given you information on our reply that shows that just simply isn't accurate. My client details for you that she did sing at a function in which she was reimbursed for gas and basically her dinner that night. We've also given you information related to this artwork, which shows that it can only be described as a hobby, not a part-time job. And again, the musical stuff, my client can't play the guitar because again, for very short intervals, that impacts the impingement on her nerves in her back, and that becomes somewhat excruciating. Contrary to that, Mr. is the one who, when they did make, again, it's modest. When they did make money, it was through his pottery. He purchased the kiln at about $2,500, other supplies for that endeavor. He made more money than she did. And again, I would certainly for today's hearing say that didn't amount to a whole heck of a lot. So we haven't included that, but we are requesting the $2,000 per month. From that, my client would make the house payment. She'll pay her car payment, which is $217. She'll pay the utilities on the house, and she'll also pay some of these credit card expenses. Again, relatively modest, but still a debt that she has that currently on her minimal Social Security she can't afford. Finally, we are asking for a award of attorney's fees and costs on a temporary basis. And we're asking for $2,500, and we're asking that any amount you require Mr. Myers to pay be paid within 60 days of entry of the temporary order.
Thank you, Mr. Zandi. Mr. Brewer.
Thank you, Your Honor. I'll try and be briefer. There's no dispute about vacating the homes. That's not an issue. As we said in our materials, my client's done that for the reasons he cited. So we're fine with an order that says she has temporary use of the home, and we can argue about separate and community ownership at a later date as to that property. As to personal property, I agree with counsel. I'm hopeful that he and I can work out the details if needed for my client to get into the home to retrieve any more personal property. If we need to follow up on that via motion, I suppose we will. So otherwise, I feel confident we can do that. This, from our perspective, is simply a maintenance issue for temporary orders. We outlined in our materials the very specific amounts each party makes, and really the analysis is this: by the time my client pays the mortgage, which he's willing to do, and which, by the way, he does already automatically through auto pay through his account of $1,021, by the time he pays that mortgage and pays for his own living circumstance, because right now he's couch surfing because he doesn't have the money to do otherwise, he will have less money than she will pursuant to both their budgets. Because if you take out the $1,021, you take out a reasonable rent figure for him, which he's entitled to live somewhere, just as she's entitled to live in the house. That leaves him with about $1,200 a month to live on, leaves her $1,400 still to live on. So that's why we think that $1,000 figure payment of the mortgage basically on that house is a fair number under the circumstances, leaves them both, him with less money than her, quite frankly, to make ends meet based on the budgets presented. We acknowledge that she receives a disability payment, but they can't deny that there is a business and that she does make a little money. We provided you the sheet that shows items for sale, which suggests that there's money to be made. We concede it's not a large amount of money, but to the extent she has any, as counsel says, minor deficits in her spending, she can use that money to cover that. And even then, my client is in more of a deficit than she is based on their budgets and amounts. So we'd ask you adopt that $1,021 figure from my client's account toward the mortgage to continue through his account. Couple little collateral issues. We don't know about the credit cards. She managed the finances, so we'd ask the court at this juncture of the case to just require best efforts and not assign them to anybody because we don't know anything about them. We're going to figure that out via discovery. My client disputes or knowledge of anyways, any large credit card balance that now she claims basically as a way to offset or require more maintenance from him. This RV is an issue, Judge. Well, nobody wants the RV. It sits at wife's daughter's house, unoccupied, and it incurs a $400 a month payment. So my suggestion or request is that we sell it or do whatever we can to get rid of it, because nobody's using it. My client certainly, their suggestion was he could live in it, but that's not something he's interested in doing. So we just soon get rid of the RV and have it sold. I believe it was in the process and something went sideways on that, but we'd like that back on. And then we'd like a directive from the court. My client wants to control solely his Fiber Federal account 5863. That's the account that the mortgage comes out of. Wife has historically kind of dipped in and out of that account. We want assurance that she won't do that anymore. This allows him to use that account going forward, prevents him from having to go redirect all of his money, Social Security and whatnot to different accounts. We'd like it all just kept through that account and her not to have access to it. His IRA is primarily his separate property incurred prior to marriage. We'll argue about that later as well. But my point is, it shouldn't just be a big pot for everyone to pull from during this temporary order period. He's going to need that money at a later date. And he stopped withdrawing from it until he gets a better idea of his finances. And finally, on fees, both parties retained counsel for similar amounts. There is no money. They're both retired, so they're both drawing on their separate funds. He doesn't have a pot of money to pay from other than his IRA, which at this juncture, given the circumstances, we'd ask that each party be responsible for their own fees. Thank you.
Thank you, Mr. Brewer. Mr. Zandi, any comment on the RV being sold?
No, I'd have to run that by my client. It was our understanding when we filed this that that was where he was going to live as opposed to couch surfing. From my understanding, it's a nice RV, does have that loan of approximately $400 associated with it per month. But I'll certainly ask her about that between now and presentation.
And any concerns related to control of the different fiber accounts?
Well, the issue with that is over the course of the past month and a half, it's my understanding he cut her off from access to that amount. And I think it's the fiber account. I think we're talking about the same one. It was down to about $160. He basically took that money, left my client with nothing. That was their in and out account that they operated from, paid the bills during the course of the relationship, which necessitated part of this motion until she's getting some kind of financial relief. I mean, she's got to pay the bills, and that was the account they did that from.
Real quick, Judge, that's not true. I'm not trying to argue with him. 5863 is my client's account that his Social Security goes into and the mortgage comes out of. They have a separate account of Fiber Federal that they're doing the in and out on. We just want control over that account related to his Social Security. That's all we're asking for, because she goes into that account and transfers money around as too. So we want to make sure that doesn't happen.
Okay. All right.
And just one point on that, the 401k, the Empower 401k, that's kind of the variable right now that that's a source of significant income. He can draw what he wants to from that. And I think the difference is in the numbers is the fact that he has now said, I'm not going to do that. My assumption is to reduce what it looks like as far as what he's taking every month, when he can conceivably take $2,000 per month from that and be just fine.
Okay, thank you. Okay, so it sounds like the parties have agreed as far as the use of the home that, pardon me, the petitioner, Ms. Myers, will remain in the home and until otherwise ordered. It seems reasonable to me that if she's going to be staying in the home, that she have that right to privacy, just like she wouldn't be able to kind of barge in on where Mr. Myers is staying. The reverse would be true also. So I'll allow and order that Mr. Myers does not have access to the home unless there's express agreement between both counsel. The issue of maintenance, it's a 17-year marriage. We look at the need of Ms. Myers. Her income is modest. It's a disability payment. And we look at the ability of the other party, Mr. Myers, the respondent, to pay. His income is slightly higher than hers, about $3,700 a month, compared to her 1,400. He does have potential for additional income through the Empower IRA, to the tune of around 400,000 at this point. So I'm going to award $1,200 per month of spousal maintenance from Mr. Myers to Ms. Myers. That puts them in rough parity. Of course, Ms. Myers will have to spend a bulk of that for housing. And she would be required to pay the housing. We'll just shift that burden to her to pay the housing, the mortgage, 2021. As far as the credit cards, I don't have a really clear idea of the credit cards. There's been a listing of cards and the monthly dollar amount and outstanding balances and who got them, but I'm just not completely sure on those, so I'm going to do best efforts to pay those at this point. And attorney fees, I'll award $1,500 toward from Mr. Myers to Ms. Myers for the attorney fees. And as far as the control of the different bank accounts, it seems like a really good idea to me at this time, that there be separation of bank accounts and each party have control of their own account. Here, the 5863 account was indicated by Mr. Myers as being his account. He'd like to have control of that. And Ms. Myers, it was represented by him that her account number ended in 3704. With the award of spousal maintenance, I don't see much need for either party to be having access to the other accounts. So those accounts will be in the control of each of those parties. And steps, I guess, would need to be taken if they're, joint accounts, or to have somebody removed or what have you, that there need to be joint cooperation to make that happen.
In a start date, Judge, for the order, it looks like this was filed back in September. Due to nobody's fault, last week we got kicked over due to court congestion, October 1st.
Mr. Brewer, do you have a suggestion?
Well, I'm not opposed to that date. I mean, remember, we've already made the mortgage payment for October, so I guess it'd be the differential due in October. And then I would also suggest, I think the mortgage payment is going to come out here any day, so maybe same thing, and then the parties can work on switching things around to be effective. So she starts making the payment December 1st. Council and I can hopefully work through those details.
Okay, let's have the start date October 15th as far as the maintenance support, and the 15th of each month thereafter.
And presentation.
Do you want to look
14th?
at the 14th?
That's fine.
And then as far as that consolidation, would somebody be able to just draft up a brief consolidation order?
I can do that.
That's kind of you. Thank you. All right, if there's no other issues, that'll conclude that hearing. Appreciate everybody's help. Thank you.
Thank you.
Thank you.
Council.